There is a lot of advice on the internet for law students about how to email a law teacher. Generally, the guidances come from teachers, with a bit of a subtext of personal disappointment or even anger. Tweets about answering student emails at odd times with little or no context are common. And look, I can agree, it can sometimes be a bit frustrating. But let's put aside the personal angst. There's an argument that it's not just about communications about a specific unit. For emerging lawyers and professionals, emailing a law teacher is a professional skill that is teachable. One-on-one communication is part of every professional's toolkit. Whether a law student is thinking about going into practice or joining another profession, interpersonal communication is a fundamental skill. That might be with clients, counsel, other lawyers, or even within the office. At one end of the spectrum, the argument of clear language in legal writing is the proverbial dead horse. The days of heretofore and aforementioned have long gone, or at least we hope they have. At the other end of the spectrum, some of the efficient informality of SMS has spilt over into emails. But clear communication is central to improving things like accessibility and efficiency in the administration of justice. Simple communication means that the purpose and intention of legal writing are quickly understood and acted on. Clear communication is a professional obligation. In an Australian context, it's arguable that it's even a professional obligation for lawyers. For example, 7.1 of the Australian Solicitors' Conduct Rules says, "A solicitor must provide clear and timely advice to assist a client to understand relevant legal issues and to make informed choices about action to be taken during the course of a matter, consistent with the terms of the engagement." A client won't make an informed choice from a poorly written and incomplete email with no context. But let's be realistic. Poor communications with a client, unless it's part of a more serious conduct, will rarely ever reach the threshold for a disciplinary matter. But it can still attract the attention of the regulator. For example, in New South Wales, the Office of the Legal Services Commissioner receives complaints about lawyers. In 2018 and 19, the OLSC received more than 6,000 phone calls, and communication was the most common complaint, second only to inquiries about the OLSC itself. The OLSC also received more than 2,500 written complaints. Communication was, again, the second most common complaint handled by the OLSC. Clear communication is what employers expect, but you're looking for an even more practical reason to be clear in your communications, right? Law students that practice good communication in their emails to you will have more luck with the job. After interviewing a slew of employers, recruiters and HR directors, Professor Bill Copland at Syracuse University published 10 things employers want you to learn in college. He listed 10 group sets that employers look for. 2 whole groups were devoted to communication, written and verbal. A little closer to home, a survey of more than 170 Australian and New Zealand firms ranked client interaction the most important skill for lawyers. Just as importantly, being able to communicate effectively online with a potential employer has advantages. In a world where law firms run more application processes electronically, avoiding slipping into informality can improve a job applicant's prospects of snagging an interview and a job.